All right, this lecture is a continuation on the previous one. We're still talking about foreclosures. So now that you have a general idea of how mortgages or encumbrances are prioritized, we're going to talk about some special mortgage priority rules. So these rules are special. They deviate from the first in time rule that we just looked at, right? So there are three instances in which will deviate from the recording rules that we just discussed. And those are if you have a purchase money mortgage. A purchase money mortgage is a mortgage in which the seller is the lender. It is a seller financed mortgage. So let's say Bob the builder purchases 2 acres of land. He subdivides it and he builds houses on it. And then he decides to finance. He will finance any buyers that want to purchase those houses. So those are called purchase money mortgages. Okay. Um, if we have a purchase money mortgage, it has priority over any other lien or encumbrance. Okay, so it will always have a priority. Um, it even has priority over things like judgment liens or community property interests. All right, so it is a very um, it is a lien that has kind of super priority. I guess you could think of it that way. Okay, the second we're going to discuss is the future advance mortgage. So a future advance mortgage is a mortgage where the lender agrees to provide additional future money, um, and that land would serve as security for these future loans. So there's two types of future advance mortgages. The first are the ones that obligate the lender to make loans to the buyer in the future. And so the lender doesn't have a choice in that matter. They have already agreed to provide additional loans. So in cases where you have these future advance mortgages that obligate the lender, any new loan will take the priority of the original mortgage. So let's say that the future advance mortgage was used by buyer A to purchase the property, and that was done in January of 2020. Then in March of 2020, buyer A takes on a small loan from another lender, so we'll call that lender 2. And then, so this is money from lender 1. Then let's say lender 1 comes back again and gives a home improvement loan based on this future advance mortgage. And they do that in July of 2020. If we followed the previous rules that we just discussed in the last video, then if this loan was foreclosed on, the order that the loans would be satisfied would be 1, 2, 3, right? But because this is a future advance mortgage, this loan here is backdated up there. So it takes the same priority as this original loan. All right, so they take on the priority from the date of the original mortgage, even though the money was distributed here. Now, if this future advance mortgage is actually just something that the future payments are optional, the lender has not agreed to provide the loans, has not obligated itself to do so. It is at their discretion, so it's optional. Then, when lender one makes this second loan here, as long as lender two has recorded this mortgage or loan against the property, so lender one has notice of it, then this loan here does not get that same protection, right? So this loan, second loan, would not have priority over lender two. Its priority date would be July 2020. All right, finally, we're going to talk about a third special situation, and that is a deed in lieu of foreclosure. A deed in lieu of foreclosure is when the lender agrees, the lender that is foreclosing agrees not to foreclose as long as the owner gives the lender the deed to the property. So they take the deed to the house in lieu of a foreclosure. Now, because there is no foreclosure, when the owner gives the lender that's foreclosing the title, that lender takes, subject to all the junior liens. Right? Because we didn't do a foreclosure, we haven't wiped out the future liens. And we're not going to wipe out the future liens at this point. So the deed in lieu of foreclosure, when the owner gives the title to the lender takes subject to junior liens. All right, let's go to your textbook, page 669. Let's take a look at that blue box, points for discussion, and let's consider some of these problems. All right, question number 1. C has recorded a judgment lien against O for $50,000. Let's pause here. Let's talk about judgment liens. Judgment liens are when a party sues another party, so in this case, C sued O, okay, and C got a judgment for a certain amount of money. Now, C is trying to satisfy that judgment against O. So how do they do that? Well, they file a judgment lien against O. That judgment lien will attach to any property that O has or acquires. Okay, so there's this judgment lien against O for $50,000. Then O purchases a home from S for $180,000. And so when we're looking at the relationship, you have O and you have S. S is the seller. So here we have S or O giving S 20,000, plus we have O giving S a promissory note and a mortgage for 160. And those are going from O to S. In return, S gives O the title to the property. So, of course, S is smart enough here to file the promissory note and the mortgage. So S records the interest. So S has 160K mortgage that's recorded against O's house. Now, because this is seller financed, a little alarm should go off in your head. This is a purchase money mortgage. Remember, purchase money mortgages they fall under one of the special mortgage priority rules. And so, S forecloses on the house because O defaults. S is foreclosing on this lien. So typically, the foreclosure only affects the mortgage and any junior lien holders, which there are no junior lien holders here. However, because this is a purchase money mortgage, S's lien takes priority over this judgment lien. So the house is sold to X. So X buys the house for $180,000. Well, 180 is not enough to satisfy both liens against the property. So whose lien gets satisfied first? Whose encumbrance gets satisfied first? Who has a priority interest? Well, as I hinted earlier, I kind of gave it away, right? S has the priority interest here. Why? Because it's a purchase money mortgage, and we said purchase money mortgages are superior interest to all other interests. Even if there is a senior lien, like a judgment lien here, this purchase money mortgage would be superior to the judgment lien. So in this case, S's lien gets satisfied first, and then the judgment, this 20K, goes to satisfy this judgment lien. Now there's going to be 30,000 left. So the holder of the judgment, C, can go after O for this remaining 30,000, but S's payment gets satisfied first. Okay, let's move on to problem number 2, and we're still on page 669. Problem number 2. So O borrows $500,000 from L1, planning to use the money to build a home. Mortgage securing the loan provides that L1 may make future advances secured by the mortgage, but is not obligated to do so. So I would, at this point, identify that we have a future advance mortgage here, right? So let's also record the first 500,000 here. Okay. O has trouble finishing the home, so O borrows another 25,000 from the second lender. And this, again, is secured by a mortgage on the property. We're going to assume here that L2 has recorded. All right. So O later obtains another $100,000 from L1 that is secured by this original mortgage. Now, L1 knows about the mortgage that O gave to L2. So here we have actual notice. And I told you that we're assuming that L2 recorded, so that would give L1 constructive notice too. All right, so a year later, O defaults on the loan from loan 2, and loan 2 forecloses. I'm sorry, from lender two. Lender two forecloses. At the sale, Z buys the property for $530,000. So who gets the sale proceeds and who gets, or what is the state of the title? All right, so how do we allocate the 500, or how do we allocate the $530,000? Well, L2 is going to be the first debt to be satisfied here. And the reason is because although it is L1 did make a loan under a future advance mortgage, L1 knew about L2's subsequent loan, and they were not obligated to make the loan here, right? And so because of that, this second advance of 100,000 here is going to take third. So first we would satisfy loan 2 here, and that gives us 505K. Then we would satisfy this 100,000, and that would give us 405K. And that remaining 405K actually goes to the owner. Now, the owner is going to have to keep making payments on this mortgage, despite Z owning the property. So Z is taking subject to L1's $500,000 loan. The foreclosure wipes out these two. So all Z has to worry about is this. All right, third problem. O borrows 100,000 from lender 1, which is secured by a first mortgage. Then they borrow 500,000 from lender 2, which secures by a second mortgage. Then they secure a third mortgage, and that comes from lender 3. O defaults. Now L1 accepts a deed in lieu foreclosure. What is the state of the title? Well, L1 has taken the property subject to, so they take it in fee simple absolute, subject to L2 and L3's interests. Since we do not have a foreclosure, these interests are not wiped out. They are taking the property subject to these two interests. All right, so we have talked about what happens at the foreclosure, before the foreclosure, and at the foreclosure. What about after the foreclosure? After the foreclosure. So after the foreclosure, there are some states that still allow buyers to redeem a property, even after the foreclosure sale. And they can do so in two ways. The first is called a statutory right of redemption. A statutory right of redemption. And with the statutory right of redemption, the borrower can regain the title and redeem the property by paying uh, the sale price that the bidder at the foreclosure sale paid, plus any costs and interests that the bidder. So let's say Z purchases the property at a foreclosure sale. O, the owner, 6 months later could come back, pay Z the price that Z paid at the foreclosure sale plus interest and costs, and the owner can redeem the property. The second way that a buyer can redeem the property after foreclosure sale is by setting aside the sale. Setting aside the sale. So how the sale is set aside will differ slightly in non-judicial sales versus judicial sales. If it is a non-judicial sale, in most of the jurisdictions, the foreclosure sale can be set aside if the price that the property was purchased at was extremely low. So the term that the courts have used is it's so low that it shocks the conscience, right? It shocks the conscience, or is, quote, grossly inadequate. Grossly inadequate. So if the sale price is too low, then the court can set aside the foreclosure sale. And the book gives kind of a rule of thumb that if the sale price is about 20% or less of the market value of the property, then that usually meets this grossly inadequate standard. All right. So it has to be grossly inadequate. For non-judicial sales, the sale can be also set aside. So we're still talking about non-judicial sales. So it can be grossly inadequate, or the second way it can be set aside is if the lender does not give proper notice. So there is no proper notice. Remember, we said that the lender has to give proper notice to junior lien holders, but also to the owner. So if there's no proper notice, the sale can be set aside. Now, if you have a situation where it is a grossly inadequate price and there is no proper notice, then you're significantly more likely to get the judgment set aside when both of these elements are present. Now, for a judicial sale, the court is looking for these two elements too, right? So they're looking again for no proper notice by the lender and grossly inadequate prices. Some jurisdictions, coming back to non-judicial foreclosures, have an extra requirement, and that is that the lender adequately advertise the sale or do a reasonable job to solicit bids, right? So the idea is that because it's a non-judicial sale, the seller, the trustee, and the trustee and the lender have an interest to not attract a bunch of bidders. They just want usually the lender to do a credit bid, right? And so because these are done outside the court sometimes puts additional requirements, and that requirement would be to basically use reasonable efforts. So reasonable efforts have to be used to solicit bids in order to get a reasonable price, right? So just back up a little bit. So, when you have an auction and you bid on something, right, the more bids you have, typically the higher the price goes. So if you want to purchase something at a lower price, you hope that there are not a lot of bids. And so here, in these jurisdictions, the legislature that enacted these laws, or the courts that added this requirement of reasonable efforts, did so because they wanted to make sure that these parties were not um, purposely excluding or failing um, to make reasonable efforts to solicit other bids so that the price would be artificially low. All right. So after the foreclosure, let's say that these are the buyer's rights, right? This is what the buyer can do here. What about the seller? I'm sorry, not the seller. What about the lender? What can the lender do? All right, what are the lender's rights after foreclosure? So the lender can seek, in some jurisdictions, what's called a deficiency judgment. A deficiency judgment. A deficiency judgment is obtained through a lawsuit where the lender sues the previous owner for the unpaid amount owed. So let's say that um, lender one, lender two, lender one had a $100,000 mortgage, lender two had a $25,000 mortgage. Let's say the foreclosure sale. The house only sold for $100,000, and so lender one's debt is satisfied. However, lender two is owed $25,000. So lender two can sue the owner for a deficiency judgment so that they can recoup this $25,000. And the suit is based on a breach of contract. The borrower, didn't meet their obligations to pay under the promissory note. Now, oftentimes these deficiency judgments, as I said before, uh, are pretty useless because the borrower is not making payments on their home loan usually because they do not have the money to do so. So even if this lender goes and gets this judgment, they're likely not going to be able to satisfy the judgment. Also, like I said, in some jurisdictions, the um, deficiency judgments are prohibited when it comes to residential home ownership. So if it is somebody's home that gets foreclosed on, there are many states have statutes that prevent the lender from coming after the borrower for a deficiency judgment. And these are called anti-deficiency legislation. There's different approaches to these anti-deficiency legislation. The book goes over three approaches. The first is a fair value fair value legislation. And in states that use this approach, they limit the deficiency judgment. They limit the deficiency judgment to the amount which the loan balance exceeds the fair market value of the property. All right, so that helps limit the deficiency judgment. The second is just a complete prohibition, which is what I've been talking about, where they just completely prohibit deficiency judgments for residential property. And then there is a judicial approach. In the judicial approach, the court could invalidate the deficiency judgment based on kind of the inadequacy of price or any unfairness in the foreclosure process. And that is it for foreclosures.